There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
Probation will be a waste of time in this matter, so I will revoke and remand you to serve your sentence. Take her into custody.
All right. $1,200 every minute I'm in jail.
Today we are covering another courtroom appearance involving a defendant using sovereign citizen-style arguments during a probation violation hearing tied to drug use. Rather than requesting a public defender, she chose to represent herself, which immediately raises the stakes given how complex legal procedures can be. Self-representation requires a clear understanding of court rules, evidence standards, and sentencing guidelines, and without that knowledge the risks increase quickly. Throughout the hearing, she repeats familiar phrases often associated with sovereign citizen rhetoric, which leads some observers to question whether she truly believes these claims or is simply repeating language she found elsewhere. The strategy appears scripted at times, yet the consequences she faces are very real and directly connected to her probation status. When someone is already under court supervision, any misstep can trigger serious penalties, including additional custody time. The judge now has to evaluate both the violation itself and her conduct in court while ensuring the process remains orderly and fair. Cases like this highlight how critical informed legal guidance can be when personal freedom is on the line. Stay with us as we examine how this hearing unfolds and what impact her decision to speak for herself ultimately has on the outcome.
This comes before the court today on a probation violation hearing. And it's the intent of the defendant at this time to stipulate. And I do believe there's a agreed sentence, as you would say in this case.
All right. Ms. Clark, you've heard the announcement of your attorney. Is that what you want to do? Admit to the violations?
No, actually, I'm going to make a motion for my attorney to withdraw. I got this myself.
Oh, okay. What's the reason for that?
I just want to represent myself.
Okay. All right. Well, somebody give her a waiver of attorney form. Okay. It's muted for some reason. All right. Well, I've already gone over these rights with you, so you should understand them, but you have the right to hire your own attorney. If you can't afford to hire an attorney, I've already appointed one. You qualified. You do have the right to represent yourself as well, and that's what you want to do today?
Yes, sir.
All right. If you want to waive your right to an attorney, when we do this, you have to follow the rules of procedure and evidence just as if you're an attorney. You understand that?
Yes, sir.
All right. Has anyone promised you anything or threatened with anything to get you to waive your right to an attorney?
No, sir.
All right. Looks like you've already signed it and sent it in here. Did you understand this form you signed?
Yes, sir.
I'll accept your waiver and allow you to represent yourself. All right. Are you wanting to stipulate to the violations, or do you want a contested hearing?
I'm going to contest it.
All right. Mr. Hollis here.
Yes, Judge, I can grab him real quick.
Okay. Okay. State has the burden. Any opening statement, Mr. Marcinski?
No, sir. Thank you.
All right. Ms. Clark, any opening statement?
With that decision, she may have weakened her own opportunity to present a strong defense. Many observers expected her to begin repeating the familiar sovereign citizen claims about jurisdiction or personal status outside the authority of the court, yet she has not gone in that direction so far. In some ways that may be a relief, because those arguments rarely gain traction and often distract from the real legal issues at hand. What stands out instead is the absence of a clear opening statement, which is a critical moment for anyone choosing to represent themselves. An opening statement allows a defendant to frame the narrative, explain their position, and demonstrate that they understand the seriousness of the proceedings. It is the first structured chance to communicate directly with the judge about intent, context, and perspective. Skipping that step or handling it poorly can create the impression that there is no organized defense strategy in place. When self-representation is already a difficult path, leaving such an important tool unused only increases the challenge. Let us continue following the hearing to see whether she adjusts her approach as the case moves forward.
State may call this first witness.
Thank you, sir. The state would call Court Service Officer Christopher Hollis. Sir, will you please state your name for the record?
Chris Hollis. I'm a court services officer.
In that job occupation, were you assigned the supervision of a Miss Ashley Clark? That supervision being for an endangering a child underlying 12-month sentence?
That is correct.
On May 18th of this year, 2023, did you test Miss Clark for the presence of drugs?
Yes,
And what was the result of that UA sample for Miss Clark?
it was positive for methamphetamine.
So her UA was positive for methamphetamines, and she also, in response to that positive UA test, signed in a statement of admission of using methamphetamines.
That's correct.
Did you order her to report on June 2nd, 2023?
I did.
And did she appear on that day?
She did not.
Has she appeared or reported to you since that time?
No.
Sometime after May 24th of 2023, were you advised by local authorities of her being arrested for a new crime?
Yes, and I did. I received that, and apparently she has new charges.
To your knowledge or to the notes, did Ms. Clark ever report that negative law enforcement contact with your office?
No, she did not.
That will be my questions for Mr. Hollis at this time, Your Honor. Thank you.
All right, Ms. Clark, do you have any questions for Mr. Hollis?
No.
All right, do you have any further evidence or witnesses, Mr. Marcinski?
Not at this time, Your Honor. I do not.
All right, Ms. Clark, you have time to, now it's your turn to present any evidence if you want to. Do you wish to present any evidence?
Right now I see no evidence. This has the needed personal subject matter jurisdiction.
If you want to present any evidence, do you want to present any evidence?
Some viewers may feel a sense of discomfort watching her struggle in such a public setting because courtroom pressure can be intense and deeply personal. Even when someone has made mistakes, there is still a human element that can make moments like this difficult to watch. At the same time, it is important to remember that she had access to legal assistance and made the choice to decline it. A public defender was available and appeared prepared to step in, which could have provided structure and guidance during the hearing. Choosing self-representation in a probation violation case carries significant risk, especially when the court is evaluating compliance with prior conditions. The decision to move forward alone shifts the responsibility entirely onto her shoulders. Sovereign-style arguments often promise empowerment, but in practice they rarely deliver favorable results in a courtroom. The judge must now focus on the facts of the violation and determine the appropriate response under the law. As the hearing continues, the outcome will reflect not only the original probation terms, but also the strategy she selected today. Let us return to the proceedings and see how the court delivers its decision.
No? Okay. Well then, closing argument, Mr. Marcinski?
Your Honor, at this time, the state believes it is shown by a preponderance of the evidence that Ms. Clark is in violation of her probation and conditions of probation imposed by the court therein. The state's going to ask that you find that she is in violation of that probation. The state would point out that this is a misdemeanor probation for endangering a child. Therefore, Ms. Clark is entitled to no graduated sanctions, intermediate sanctions, or other relief as set forth by the legislature on felony probations. Due to the litany of violations, the continued drug use, the failure to follow through with her treatment requirements, the state believes that she's shown that she's not amenable to probation and would recommend the court revoke and remand her to serve her underlying sentence.
All right, Ms. Clark, closing argument?
There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
Okay. It'll be the order and judgment of this court. Well, first of all, I'll make my findings. The state's shown by preponderance of the evidence that you violated probation in this case using methamphetamine. around the 18th, as evidenced by the 18th of May this year, as evidenced by the positive UA and the admission. Also find that you failed to report in violation of probation as alleged. That would be the June 2nd, 2023 date. You failed to successfully complete outpatient treatment at Summer Mental Health as ordered by the court, so I find you violated probation there as well. You also failed to report law enforcement contact within the business day in violation of the orders of probation. You have violated it does in a very substantial way. I will go ahead. It appears as if probation will be a waste of time in this matter, so I will revoke and remand you to serve her sentence, take her into custody.
All right. $1,200 every minute I'm in jail.
Her demand of $1,200 for every minute spent in custody immediately shifts the tone of the hearing because it shows a complete misunderstanding of how the justice system operates. She is already before the court for violating probation connected to drug use and concerns about child safety, which are serious matters on their own. Instead of focusing on accountability or rehabilitation, she attempts to argue that she should be compensated for time in jail, which only deepens the concern surrounding her judgment. When someone is under probation supervision, the expectation is strict compliance with the conditions set by the court. Violating those terms, especially in situations involving the welfare of a child, carries significant legal consequences. Suggesting that the state owes payment for lawful detention reflects a belief that personal interpretation overrides established law, which is not how sentencing works. Courts do not provide financial rewards for time served after confirmed violations, and there is no mechanism that supports such a claim. The judge must evaluate the probation breach based on evidence and statutory guidelines rather than emotional statements or bold demands. This hearing highlights the contrast between courtroom procedure and the alternative narratives sometimes presented by sovereign-styled arguments. Share your perspective on how this unfolded and whether you believe there is any realistic path for her to reduce the impact of these violations as the case moves forward.